in the matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, Counselor, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
What? This is what he's out. Yeah, he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get discovery. It's not the prosecutor.
Well, the first thing I want. Okay,
You want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they sent me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial today?
Well, let's see what the discovery evidence has to say. But first, if they could, the very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say, can you
I'm send this to the assignment clerk, Mr. Lanto, you're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking crazy.
Oh, yeah.
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And then number two,
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no. The proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time, and your attorney will be here in person, and we can talk about it. So when you get that letter,
well,
can I put on there that he's in person? I'm gonna indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
Well, I feel like
Is that-
I'd be in danger if I came there, I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
would
thing I
you
could
watch
ever
over
hear.
him when he comes?
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I gotta come in person and you're gonna assign a police officer to me and then you said I'm talking crazy?
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
You said no, you said it in reverse. I said first that you're talking some crazy talk. Then I said, I'm gonna adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days. People versus William Vaughn. Mr.
Yes.
Vaughn here.
Yes, sir. I'm
Mr.
here.
Vaughn, can you hear me?
Oh, then.
Yes, I can hear you.
Okay. Counselor, you want to put your appearance on record?
Thank you, Robert Coots, on behalf of Mr. Vaughn.
Okay. But indicating you want to set this matter over for a jury trial, is that right?
That is correct, Judge.
Okay.